Oye, oye, oye. Anyone having business before the King's Justice, Superior Court of Justice, attend now and you shall be heard. Long live the King, the Honorable Justice Hennessy presiding. Please be seated. Good morning, all.
Morning.
Mr. Schachter.
Good morning, Your Honor. Yesterday, I spoke a little bit about 109, 111, 112, and I don't want the court to think that by talking about those important issues that the plaintiffs think that decision has to be based on those sections in respect of direct liability to us. I want to make sure the court understands that the source of the Crown obligation to the plaintiffs is not the Constitution. The source of the obligation is the treaty, and it is the Commonwealth common law applicable to that to the case that assigns responsibility really as set forth in Grassy Narrows, which in a few words is each to the extent of their jurisdictional capacity. So I just wanted to make sure that that's not lost. Second thing I wanted to do this morning is I wanted to dive right into the question about sacredness. The court had asked each party to respond. We adopt what the group of seven has quite eloquently actually said about that. I wanted to remind the court what the Court of Appeal had to say about sacredness. At paragraph 111 of their reasons, they say this: the court must take a purposive approach to the interpretation of a treaty obligation informed by the honor of the Crown, recognizing that treaty promises are solemn promises and that treaties are sacred, both solemn promises and sacred being in quotation marks. Now, in our view, sacred is more than just really, really, really important. This sacred compact is one built on a foundation of respect, responsibility, renewal, and reciprocity. It is above all a relational agreement among nations. So in this sense, I think you can say it is sacred, that it is inviolable and must not be broken is another feature, as Ontario pointed out. But I think to be sacred means more. The sacredness reminds us of the way the treaties parties got to the agreement through ceremony and the abiding respect for Anishinaabe customs and traditions at the council fire, and an abiding respect by the Crown for the Anishinaabe world order and a nation-to-nation compact where partners are equal. This, I think, this sacred nature of the treaty in this context helps define its content. The sacred nature of the treaty is ground in both the history and the foundation of treaty making that was the course of relations between the Anishinaabe and the Crown for hundreds of years before 1850. I think also that the sacred nature of the treaty speaks to the forward-looking relationship among equal nations who are cohabitating in the space we now call Canada. I hope that helps, and that's my comments on sacred.
Thank you.
A very brief note on NAME and the NAME negotiations, the group NAME group that calls themselves, that we call NAME. On the holdback issue, we continue to rely on our main and reply submissions. We say that NAME's submissions were inconsistent with paragraph 2Q of the intervention order and should be ignored. We do say that.
Say that on the basis that Mr. Gover put forward the other day, that that order didn't just apply to
this oral hearing, but applies as throughout their.
Well, I would adopt that, but there's a more fundamental point here. It makes no sense for NAME to advocate. Remember, they could advocate, if we accept that they can advocate for whatever they want to advocate for, it's in respect of what's held back. If nothing is held back, there's really nothing for them to advocate for a more of a share of the 100%, which has already been distributed. It's only if there's a holdback that they could advocate for part of what is paid to the, or reserved for the 12 First Nations. What NAME could do after the fact is say to Canada, you should be holding back X dollars for the NAME group. I think that's fine, but not holding back from the 100% of.
Holding back or setting aside.
Setting aside, yes. You should set aside, Canada, independently of what you pay the plaintiffs and the group of 7. You should set aside an amount for us. I think that NAME could do.
You
But
think the court can do that?
yeah, I think the court can do that as well. And it's actually the sensible approach. At this stage, the court could say, I have found that 100% of what is owed to the plaintiff is X dollars. And given the representations from Canada, I'm directing Canada to set aside an amount of X, or an amount of a percent of X, not out of the X, but just an amount to satisfy any NAME claim should it arise in the future. Or you could just say nothing and just leave it for the post motion for Canada and the NAME group to work out what that percentage, what that amount should be.
And the reason I ask about that set aside is I don't necessarily think that is the an answer to it, because the plaintiff's position is the Crown has capacity through the Consolidated Revenue Fund to do what it does, to pay. So does the Crown need to be told to set any amount aside? Well,
I didn't want to water down the argument of the NAME group, but yes. That's the truth of it.
Right. The corollary to that argument from them is that the NAME group should control that money in the interim. But
you're not asking me to comment on that?
No, I'm not. I'm just saying that's my understanding of that part.
I'm not sure that the NAME group would, sorry, I'm not going to comment on it.
Thank you.
Yeah. I wanted to return then to reminding the court of the importance of treaty interpretation. It seems that it's almost as though the principles of treaty interpretation have been forgotten in terms of this phase 3. And I want to read from the Court of Appeal at paragraph 324. At 324, the court says, the remaining task of interpretation and the basis of implementation lies in determining the sharing relationship envisioned by the Anishinaabe and the Crown in 1850 would look like today, and how that relationship can be brought about. This is the task of reconciliation. What this tells us is that it's the court who is going to, through its interpretive process, help with reconciliation. And it is useful to remember some of the principles of Marshall as you go through your exercise of interpreting the treaty obligations and what duties are required to fulfill those obligations. I just remind you of the principle that treaties should be liberally construed and ambiguities or doubtful expressions should be resolved in favor of the Aboriginal signatories. You might recall that the goal of treaty interpretation, while it is to choose from among the various possible interpretations of common intention, it's the common intention that reconciles the interests of both parties, not a unilateral expression of Crown interest. In searching for the common intention of the parties, integrity and honor are to be presumed. And of course, one canon of interpretation that I think strikes at the heart of Ontario's case, a technical or contractual interpretation of treaty should be avoided. So I don't need to belabor those points, but it's worthwhile just remembering the court is still engaged in an interpretation of obligations under the treaty, and those liberal principles of interpretation should be brought to bear on the court's thinking. Yesterday, oh, sorry, I'll wait for you to catch up.
Go ahead, thank you.
Yesterday, there was a discussion by Ontario's council regarding equitable compensation, and you had asked the question about, well, you know, Canada had said that there's a couple aspects of equitable compensation, hindsight and deterrence. How is it that those should apply? And I want to sort of get into that and give you my own answer on that. The place I want to start is equitable compensation and the Chippewas of Nawash case. Remember, in that case, the Court of Appeal at paragraph 299 actually finds at item number 3, Ontario's appeal from the findings that the Crown breached Treaty 45.1.5 or 45.5, excuse me, by failing.
Paragraph 3.
It's paragraph 299, item 3 of the disposition by the Ontario Court of Appeal. Ontario's appeal from the finding that the Crown breached Treaty 45.5 by failing to perform the treaty promise with sufficient diligence is dismissed. So what we have here is a breach of the duty of diligent fulfillment. And at paragraph 153, the Ontario Court of Appeal tells us that the many-hatted Crown, whether it's in fiduciary obligations or in respect of honor of the Crown, poses no problems for allowing equitable compensation. Remember, the failure in Chippewas of Nawash was failing to prevent squatters from coming onto the land. And so the claim made was not a breach of treaty. The claim made was for breach of diligent implementation of the treaty. And the court comes to the conclusion in respect of that breach at paragraph 292. Finally, we are, under the heading Roman numeral 4, equitable compensation from the Crown would be an appropriate remedy for the failure to diligently perform the treaty promise. Paragraph 292. Finally, we are persuaded that equitable compensation payable by the Crown would be an effective remedy in the circumstances. Now, we would say that in each case, the unique circumstances have to be looked at. And I want to return to what,
Can I see
Yeah.
if I understand this?
yeah,
You're saying the court dismissed the claim for breach of diligent
no,
implementation?
no, 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 they dismissed Ontario's appeal of the finding that they had breached the duty of diligent implementation.
Right. Thank you.
And then what I wanted to get to was paragraph 153, where the Ontario Court of Appeal has some, I think, some important guidance for this court. Finally, Ontario argues that the trial judge erred by suggesting that the Crown could not take the competing responsibilities and obligations into account when implementing a treaty promise. First, we accept that competing Crown obligations can be considered in evaluating the duty of diligent fulfillment, but how and to what extent depends on the facts of each case and the nature of the treaty obligation. And then they continue a couple lines down in still under paragraph 153. In our view, the trial judge's analysis simply recognizes the obvious, which is that the Crown's honor cannot be compromised by interests that are axiomatically opposed to those that the Crown has promised to protect. Stated otherwise, white settlers' need and desire for land on the peninsula is not a competing interest, but one that is diametrically opposed to the Crown's promise. So what this tells us is that the court you've heard the expression, the many-hatted fiduciary, and what this is telling us is that, I don't want to say contrary to Justice Horrigan, because Justice Horrigan was,
I say this was addressed by Justice Horrigan.
no, but Justice Horrigan was addressing ad hoc fiduciary duty. And his conception of ad hoc was forsaking the interests of all others to the exclusion of all others, that you cannot wear many hats. But of course, we know that in the sui generis fiduciary duty, that's exactly what the Crown does. It wears many hats and balances interests. And what the Chippewas of Nawash case is saying is simply that very same balancing can go on in respect of a duty that arises from the honor of the Crown, duty of diligent fulfillment of treaty. So the idea that there is balancing is not something that is inconsistent with equitable compensation. Indeed, were it otherwise, there wouldn't have been equitable compensation in Garin. And the Court of Appeal would not have said there should be equitable compensation in Chippewas of Nawash. The two are not mutually exclusive. Any questions on that?
I presume you're not asking to revisit fiduciary duty. You're only talking about equitable compensation.
I am talking,
Response.
yes, I'm not asking for fiduciary duty at all. I agree with the Court of Appeal that fiduciary duty has no work to do that the honor of the Crown cannot do. And paragraph 153 of Chippewas of Nawash basically, I don't want to say turns honor of the Crown into the many-hatted, what is equivalent to the many-hatted fiduciary, but that is the core of what they're actually saying. That's my take on it. And it makes actually a lot of sense too. but I'm sort of forced into discussing this today with you because of the Crown's insistence that there's something magical about fiduciary duty that takes you out of equitable, the equitable remedies, equitable compensation principles that I'm about to advocate for. And I'm going to get into that right now, unless you have more questions about that part. Okay, so let's get into the two principles, the deterrence and the hindsight, and I want to address how the Crowns, I think, have got it wrong. In our main submissions, it's at part 3, pages 28 to 70. And no, I think I've got, is it pages 28 to 73 or paragraphs 28 to 70? Here, right here, let me.
Your shorthand hindsights for this issue, is that best and highest use?
Yes, yes, that is correct. I said pages 28. Yes, it's part 3, starting at page 28, going all the way to page 70. So I actually spent a fair bit of time in my main argument dealing with that. And we further elaborated on why hindsight or highest and best use and the Brickenden rule would be appropriate remedial approaches in this case in our reply at paragraphs 132 to 157. Now, in response to Ontario and Canada's position on deterrence and your question about deterrence, I don't think I have to do more than turn up or read from Southwind, paragraph 144, what they say about deterrence. And I just want to read it and think about it for a moment. Deterrence has special importance in this case because deterring the Crown from breaching its fiduciary duty encourages it to act honorably and orients it towards the ongoing project of reconciliation. As this court stated in Williams Lake, the just resolution of claims arising from the Crown's failure to honor its obligations is essential to reconciliation. Now I'm going to pause and stop that. What they've said, true, it was in respect of fiduciary duty, but you could say the exact same thing about treaty fulfillment. And they continue on, given the facts of this case, including Canada's inexplicable conduct, the fact the land was never legally surrendered or taken, and the significance of the harm to the First Nation, the trial judge must seriously consider whether the total award will be an effective deterrent, thus reflecting the honor of the Crown and the goal of reconciliation. Both the honor of the Crown and the goal of reconciliation are inextricably tied to treaty fulfillment. The idea that Southwind is getting at is applicable in this case.
So they raise, or do they raise the amount of the award? Is that what they said? The trial judge must seriously consider whether the total award would be effective deterrent?
Yes, because all that was being sought.
How many zeros were in the award? Southwind.
Well, there hasn't been an award yet because.
But what was wasn't there a range in the claim?
Well, I don't know how much the Southwind plaintiffs are now. It hasn't come back to court. Maybe they're settling, maybe they're not. I can tell you what the trial judge, who was considered wrong, I believe he had an amount for the breach. I believe it was $34 million or thereabouts. But it was the Supreme Court of Canada said he was wrong. He used the wrong methodology and sent it back. So that's where we're at there. But your question is, well, what do I do with that, Mr. Schachter? Is there any guidance on how that ups the dollar amount? And the answer in this case, I've said it before, is we're actually not looking for deterrence in the dollar amount of the past compensation. We're looking at the importance of deterrence to facilitate treaty fulfillment and reconciliation in a forward-looking way. And we say that this factor of deterrence helps you put more concrete guideposts than you might otherwise. I hope that answers the question.
Yes, thank you
Yeah.
for helping me recall that.
In respect of hindsight or highest and best use, we explained at our reply, paragraph 141 to 142, and the group of 7 did so in their reply at paragraphs 24 to 37, that the rationale for employing highest and best use is actually not confined to or derived from equitable principles, but is derived from the evidentiary difficulties in bringing definitive proof of the loss to the court's satisfaction. And I can do no better, I think, than quote from the TicketNet case that Canada at tab 17, exhibit LL, sought to rely upon. And the principle was cited at paragraph 85 of TicketNet. Does the court want to turn that up, or I can just read it?
What does it?
Yeah, sure. 85. In my view, this is the Court of Appeal. The maxim, and that's the maxim of the reverse onus. In my view, the maxim should only apply where the wrongdoer, sorry, not the reverse onus, the presumption of highest and best use. In my view, the maxim should only apply where the wrongdoer's acts make it difficult or impossible for the innocent party to prove its loss. They then go on to say, or where the facts needed to prove the loss are known solely by the wrongdoer and the wrongdoer does not disclose these facts to the innocent party. So that's the framework used at paragraph 85 before the Court of Appeal then adopts Wadham's formulation, which is a little bit different, where Wadham says at paragraph 13-250 of his work, and this is right at paragraph 85 of their decision. However, the examples collected in the preceding paragraphs and elsewhere in this work indicate that in cases where the nature of the wrong itself makes it difficult for the plaintiff to establish a loss, or where the critical facts are peculiarly within the defendant's knowledge, the maximum or its equivalent will be invoked for the plaintiff's benefit. And that might be a typo. I think it's the maxim, not the maximum. Or its equivalent will be invoked for the plaintiff's benefit. So that is a proper statement of the law where you would invoke the presumption. We say that is precisely on all square with this case. The Crown's conduct has made it difficult for us to marshal definitive evidence. Canada, in its oral submissions, sought to limit the application of the principle by reference to section 87 of the TicketNet case. But at paragraph 87, all the Court of Appeal is saying in TicketNet is that the trial judge did not depart from the basic tools in Friedhof. Well, the basic test in Friedhof, excuse me. Well, what is the basic test in Friedhof? We find that at paragraph 81 of the very same ticket net decision. And I'm paraphrasing, but it's essentially that where the presumption of hindsight does not apply, the plaintiffs must prove their case on the balance of probabilities, and that the projections, or you could call them estimates, must, according to the Ontario Court of Appeal at paragraph 84, constitute a close approximation of what would have occurred had the contract been performed. Now, there are words in the lower court's formulation that the Ontario Court of Appeal did not adopt. The Ontario Court of Appeal did not endorse the notion that proof had to consist of elements of reality, certainty, and non-speculation being present to a reasonably high degree. That is a formulation by the trial judge that I say are obiter, and which the Court of Appeal did not adopt. You can see that at paragraph 84 that they didn't adopt it. They had their own formulation, which I just read to you. Now, I would agree that at common law, proof cannot be speculation. I agree with that. And I agree that it must be based on evidence, and I say in this case it is. And I would also agree that there has to be evidence that's within the realm of reality, but that's in the sense, I say, of common law causation. But I do not agree that the law requires certainty. To me, when I see the word certainty, that sounds like a burden of proof that is even higher than the criminal standard of proof of beyond a reasonable doubt. And I am certain, and the Supreme Court of Canada has reminded us a number of times, there is only one civil standard of proof when you're not talking about presumptions, and that is proof on the balance of probabilities, sometimes considered more likely than not, and on a consideration of all the evidence. There is no requirement of certainty or any proof to a reasonably high degree. Now, that is just a wrong statement of law, and the Court of Appeal does not adopt it. I would remind this court that the plaintiffs do say that the evidence tendered by them does meet the civil standard of proof, and that we do not have to rely on the presumption of highest and best use, or on the reverse onus of who has proof, who has the obligation to prove the loss or to negative the loss. We say on the balance of probabilities, the plaintiff's collective annuity payments would have found their way into uses or into investments that would have returned at least an average of 7.2%, if not more. We say there's evidence to support that. And we say, secondly, on the balance of probabilities, keeping in mind that had the engagement process taken place, it would have been an engagement process with a Crown who honorably and in a fulsome way embraced the obligation to fulfill the purpose behind the promise. The purpose to share in the future potential and future opportunities of the treaty territory. Therefore, we say the engagement process would, on the balance of probabilities, have resulted in some consideration and some accommodation of the plaintiff's interests in increasing the revenues, whether by increasing the Crown pie or by treating the Crown pie as though the Crown had captured more of the resource rents without actually capturing them, and that's the Carney proposal. And Carney, by the way, was just not some nobody. Carney was the commissioner of Crown lands, so that's a somebody.
I just have a question, please.
But he wasn't. I've got, my friends have told me that I have made a mistake there, and he wasn't the commissioner of Crown lands. I'm going to check my notes. I thought I had that on a letter from him, but if I'm going to check during the break, and I thank my friends for correcting me if I'm wrong.
Thank you. There was, I can't remember whether it was Professor Messamore or Ms. Jones who gave us a list of characters. So maybe there was.
Yeah, we'll go to there, but I'm going to see. I didn't think I made that up, but we'll have to find out.
What was I going to ask? So I just had a question on your very last proposition. The engagement process would have resulted in a process by either increasing the crown pie or treating the crown pie as if it had been captured as per Carney. And I'm presuming you say that the engagement process could have also covered topics of control of money, how it's paid, those questions which we had a discussion about yesterday, whether the Crown could put money in a band trust account or
would
hold on to the
perhaps
capital.
enact legislation to do so. Yeah, I have no doubt that in the real world, and common sense tells us that those discussions likely would have taken place, but common sense doesn't tell us what the result of that would have been. And I want to return to a point I think I've made in my argument somewhere. If the court is with me that we have proven on the balance of probabilities, given the nature of the Crown conduct required, and I've just said that a Crown who embraces the obligation, that it would have responded appropriately and there would have been some increase or some accommodation. We have now proven our case that there has been a loss, and you shouldn't, and I said this in my written argument, don't confuse proof of the existence of the loss with the quantification of the loss. Right? So we have not been able to prove that our loss of opportunity is the amount up to $126 billion. We haven't been able to prove that there would have been a capture of up to 126.3 billion. We haven't. We couldn't because we didn't have the opportunity. So we don't know, but that doesn't preclude the court from saying, yes, you have proven that there is a loss. That's not speculative. You've proven it on the balance of probabilities. And now I, as the court, am faced with the difficult task of doing the best I can to quantify what that loss is. How much more over, and I'm just going to use the numbers we used, 77 billion, the amount captured directly and indirectly, how much more is it appropriate for this court to award in recognition of that loss? Is it, as the plaintiffs say, based on highest and best use and presumptions, and taking into account the deprivations that far exceed the 126? Should it be set at 126? Should it be something less? This is a task for you in quantification. Once you get over the first hurdle of causation, in common sense causation of that there would have been a loss.
Let me just catch up, please. So on this point, you start by saying, first, don't confuse proof of evidence of loss with the quantification task.
Yes.
Second, you say, we haven't been able to prove there would have been a capture up to 126 billion,
But I think we have proven there would have been some accommodation.
right?
And so that's an issue of quantification, not an issue of a proof of loss, yes.
But your last, it's just your very last point on that you say, then the court's task is to quantify how much should be awarded in recognition of whatever loss proven. Is that it?
Well, the
You say
law.
over 77 billion, but
Because I'm distinguishing between loss of opportunity, which is the loss of opportunity to engage in a process to increase either the pie or the capture part of the pie that's captured, right? That and the part of the slice of the pie, if you will, that the Crown captures.
size of slice or size of pie.
Sorry, let me just try and clarify. Remember, our position is we're only talking about the global pie that actually did exist, not the potential pie, right? So we're talking about the possibility of capturing more than 77 billion worth of pie. That's what we're talking about. That's the lost opportunity between using our numbers between 77 billion and 126.3 billion. The reason why I separated is because Ontario and Canada and the plaintiffs all agree that the treaty right is to share in the net Crown resource revenues, which we would say is direct and indirect, which is 77 billion. That's the treaty right. But the breach of that right, and leads to 77 billion, but the breach of the engagement process by which the pot could have been bigger is where the rents come in. I'm going to get to that a little bit later in more detail, I hope. But that's the basic point that I think you're asking about right now.
And I think the way I distinguished it, which may be helpful, there are two different concepts: the size of the pie and the size of the slice.
The size that, when you say the size of the pie, we're talking about there's
the potential that it could have been bigger, and that's
the Crown could have captured more of the pie that existed, and if they did, they could give us a larger slice, right? Or more accurately, we could have come to an agreement that our slice would have been larger. Now, so I've dealt with the presumption of law, but Ontario made an interesting argument yesterday in their oral submissions about linking the hindsight rule to controlling of beneficiaries' property in fiduciary law. And so the argument Ontario advanced was, look, at the idea of hindsight and best use is inextricably linked to the fiduciary's control over property. And I'm going to try and convince you that that's a wrong formulation. So first place I want to remind the court is, in their oral submission, Ontario ignored the genesis of the presumption that we've just talked about. Not equity, it's the common law. And their link to the control over a beneficiary's property with respect misses the mark. We say It is not the proprietary interest in a property that the courts are concerned about when the hindsight presumption in equity is applied. The court, I think you tweaked into this yesterday with one of your questions. We say the court in equity is concerned with supervising a societally important relationship where the wrongdoer has prevented a plaintiff from taking advantage of an opportunity that the plaintiff should have had. Now, in a fiduciary duty case, the plaintiff lost the opportunity to use their own property because the fiduciary has control over the property. In the treaty case, such as this case, the plaintiff has lost the opportunity to use what should have become their property, but which the wrongdoer, who we must remember remains in a fiduciary relationship with the First Nation, has wrongfully withheld.
And just to be clear, when you use the word property in this proposition, you're talking money.
In my last proposition, when I say to use what should have been their property, the money should have been theirs.
Right. The
Yes.
plaintiffs lost the opportunity to use what should have become their.
Right. And I'm going to try and convince you that the should have become their property and is their property makes no difference. I start with the proposition that the hurt and the harm to the relationship at the heart of the obligation, be it fiduciary obligation or treaty obligation, has the very same sting. Both the beneficiary in the fiduciary duty context and the treaty beneficiary in the breach of treaty context have lost out on an opportunity that a person who stands in a most solemn, inviolable relationship has brought about by their breach. The harms are indistinguishable. So too, we say, should the remedies. And to square this circle, I want, and to have you hopefully agree with me. Well, no, don't agree with me. Agree with the Supreme Court of Canada. The Supreme Court of Canada in Southwind in Canada, 2021 SCC 28 at paragraph 60 addresses this very issue of the important, is it the proprietary interest that's important, or is it the relationship? They come down on the side of the relationship, and here's what they say. Paragraph 60. Rooted in the honor of the Crown's fiduciary duty exists to further a socially important relationship. Well, that's the honor of the Crown. You could say that about treaty. It structures the role voluntarily undertaken by the Crown as the intermediary between Indigenous interest in land and the interests of settlers. Then they say this, they quote from Professor Rotman, obviously with approval. Professor Rotman, in the context of fiduciary relationships generally, puts it this way. While it may appear that the fiduciary concept exists to protect beneficiaries' interests, that effect is merely ancillary to its protection of fiduciary relationships. So the Supreme Court of Canada is expressly telling us that it's not the interest, not the proprietary interest, that is at the core of the obligation that is to be protected, that gives rise to equitable treatment. It's the relationship that matters. And the relationship in this case, a treaty relationship, is most solemn. And we return to the solemnity of promises made. Now, I've already talked about the plaintiffs not asking for an elevated fiduciary duty. I think in our discussion, we've already dealt with that. I want to turn to sorry, did the court have any questions about what, okay.
Thank you.
I want to turn to understanding the rights and duties at issues in this case. First place I want to start is it's really important in understanding this case to distinguish between the various rights and obligations. The first right is the treaty right to engage in a process to determine what the net Crown resource revenues are. And I want to read what this court wrote, paragraph 525 of the phase 1 judgment. And it's towards the end of paragraph 525. This court wrote, rather, sorry, I'll start from the middle of the paragraph. It is a promise to engage in the process of implementing the conditional augmentation promise. The legal interest subject to the duty is not an absolute right to increases and is not in relation to the administration of the land. Rather, the legal interest created by the augmentation clause is to engage in the process to determine whether increases are payable. The right to have the Crown engage in the process came into effect upon the signing of the treaties and continues to exist today. So what we have, and if you look at the judgment 1B, that 1B Roman numeral 1, that's followed through in the Crown's obligation to periodically engage in a process in consultation with the First Nation to determine the amount of net resource-based revenues. So that's one treaty right, the right to an engagement process. Secondly, we have the right, the treaty right, to have the annuity augmentation increased if there are net Crown resource-based revenues that permit the Crown to increase the collective annuity entitlement without incurring loss. And that's pretty much taken from paragraph 1A of the judgment. I don't believe there's much of a dispute about that that's a treaty right to be paid if certain events happen. But those are the treaty rights at issue in this case. But the law also provides guidance and engrafts other duties, other rights over and above the treaty right that must be performed by the Crown that speak to how the treaty's obligations are to be performed. So recall the law. I'm not going to go into the law. I think the court knows these principles. The honor of the Crown is a constitutional principle and is said not to be a cause of action in and of itself, but speaks to how obligations to which it applies must be performed. Therefore, for example, in a pre-proof situation where there are only claimed rights, the honor of the Crown gives rise to a duty to consult and, where appropriate, accommodate. In the post-proof stage, which is where we're at now, the honor of the Crown gives rise to a duty of diligent and purposeful fulfillment. Now, we don't need to turn it up, but you will see this precisely at paragraphs 241 to 242 of the Court of Appeal decision in this case. But it is important to remember that the treaty rights are different than the right to have the treaty fulfilled in a diligent and purposeful manner. Point is that one can breach the duty of diligent and purposeful fulfillment without necessarily breaching the treaty itself. I want to give you an example. In many treaties, there is treaty land entitlement promised. The promise contains no date by which the reserve land must be set apart. If the Crown sets apart the reserve land only 15 years later, it has fulfilled the treaty obligation, but it has failed to do so in a diligent and purposeful way. It has done so without honor, and this is why the court has engrafted this additional duty that, in the context of the way the courts have dealt with the diligent and purposeful fulfillment, it is those such as in Mikisew where you don't have to go to justification. So where there is a treaty breach established, the onus shifts to the Crown to justify its offending conduct. It has an onus to establish that the conduct is justifiable. Mikisew 2005, for example, is a good example not of a treaty breach, but a breach of a duty flowing from the honor of the Crown. Remember that in that case, they claimed a treaty breach, but the court said, no, this isn't a case of treaty breach. This is a case of failing to do something that the honor of the Crown requires. And the Supreme Court of Canada explained that that kind of duty to consult and accommodate doesn't attract the Sparrow test of justification, but engages a balancing approach in assessing Crown conduct. The very balancing that at paragraph 153 of Chippewas and Nawash that the Court of Appeal is talking about. But engaging in that balancing process is different in the and when you look at diligent and purposeful fulfillment than when you're talking about treaty breach. The Crowns have made clear that the conduct required to fulfill the duty of diligent and purposeful fulfillment need not be perfect. We agree with that. But the breach of diligent and purposeful fulfillment is not a defense to failing to do that which the treaty requires. The treaty breach. And what we have here, it's breach of treaty. We have a breach of the treaty right to an engagement process and the breach of a treaty right to payment. I want to remind the court that what the Court of Appeal said at 323.
I just go back to.
Yeah, sure.
But a breach of diligent implementation is not a defense to breaching the treaty?
That's correct.
Or are you saying that not achieving perfection?
That would be a better way of putting it. Yes.
Okay.
Right. Just because, or maybe I could put it both ways. Simply because the Crown says we have a duty of diligent implementation doesn't relieve them of fulfilling their obligations to actually do what the treaty requires.
Well, is another way, I'm just hoping I understand you, so I'll try and feed this back.
Yeah.
In the two examples you've given me, one, if there's a treaty promise to set aside reserve land, and that's ultimately done, but it has been delayed. The court might say, or one might say, that ultimately the treaty promise was fulfilled, but there has been a breach of the duty flowing from honor of the Crown to diligently implement the treaty, and that is separate from, the breach of that duty is separate from a claim for breach of treaty.
Right.
And so in this case, similarly, one might say, should tomorrow the Crown compensate or fulfill the treaty promise in some way that is considered fulfillment of the treaty promise,
Yes.
the action for, or the plaintiffs say the loss from that delay still exists. Like for instance,
That's if it's not compensated for, yes.
right. So if just the treaty promise, for instance, the treaty promise perhaps in nominal values,
Right.
what if the Crown said to the plaintiffs or to the court, well, we have sent a check for nominal values. We've looked at nominal values. This amount represents nominal values. Then the plaintiffs might still argue, this is what you're saying,
Yeah,
that this delay has caused a loss.
that's
And
right.
that loss is separate and different from the fulfillment of the
That's correct. I think it's important to conceptualize them differently for that reason. And because they lead to different paths. In one, the breach of the honor of the Crown duty to consult, there's this balancing going on. But when it comes to the duty of payment, it's not optional for the Crown. If it happens, if certain facts happen, they're objective facts. If they happen, if there is enough wealth, and if they can do so without loss, then in fact, they have to pay. It's not a discretionary thing. And this is where we must be sure that we put the discretion where it belongs. They have discretion in this case into how to take part in how the engagement process might unfold. They can set the time that we meet. They might discuss with us and say, in our view, you should be funded X amount of money for lawyers and economists, and you've put in a budget for Professor Stiglitz for 2027, but we think you should be hiring someone who's less expensive. You want to bring all chiefs in council to the meeting of 12 First Nations. We think that it's more reasonable that you should only bring one. I mean, so there is this discretion that the Crown has in the engagement process, but they don't have discretion to decide whether or not to pay. And where I was just going is to remind the court what the Court of Appeal said at 323. And this seems to be lost on the Crowns in their submissions. 323, I'm reading from the second paragraph of 323 after the trial judge was quoted. The parties in negotiations or the trial judge in stage 3, not in stage 4, not in stage 6, not sometime down the road, the trial judge in stage 3, where we're at now, must determine the form, level, and aim that the augmentation clause requires. And then it goes on to talk about the shared goals, expectations, and understandings. And that's why the judgment, that's why the Court of Appeal left the judgment where it is the court decides what the amount of the net Crown resource revenues are. The court decides on what the pie is to be shared, or the imputable pie, and also decides in this case what the slice of the pie for the Anishinaabe is. That's your job. Failing agreement. Now we haven't, because the order says failing agreement. We haven't been able to reach agreement. That's why we're here. We're asking for our rights to be vindicated. The court might side with us, might side with the Crown's, court might take some place in the middle, but the court's role is to decide this issue, not to kick it back to the Crown, thinking that on the basis that they have discretion to decide any of this. They don't. I just remind you that it's paragraph 3A of the amended judgment in addition to section 323 I just read, that leaves it to the court, not the Crown, to determine the net Crown resource-based revenues. And it's 3C of the amended judgment that makes it clear that failing agreement, the principles to be applied are to be subject to the directions of the court. Well, obviously, we're here in court seeking those directions. Both Crowns somehow, in my mind, interpret the availability of discretion within the engagement process, how it unfolds, when it takes place, who is invited, what information is disclosed, and what proposals they may have for implementation, as permitting them to avoid the words of the judgment that leaves the matter of the final determination of the amount as well as the share to the court. I ask the court to remember that on the issue of discretion, this point was argued strenuously at stage one, where Ontario said the graciousness clause is a recognition right in the treaty that we, the Crown, have the discretion to decide if there's going to be an increase. We, the Crown, get to decide on the form and level and aim of the augmentation. No, said this court. No, said the Court of Appeal. That graciousness provision identifies the discretion, that the discretion is limited to how much of the slice, Anishinaabe slice, can go to individuals. And there was a good reason for that back in 1850. But that is where they have discretion. And it's a little bit, not in keeping with principles of liberal interpretation of treaties, where you have an express clause that says, here, Crown, here is where your discretion lies. And then other clauses where that express reservation of discretion is absent, to somehow come full circle, as the Crowns do in phase 3, to argue that they have the discretion to decide these things when they are for the court. So with that, I think before the break, or I could break now, or I could turn to a small section on justification.
Let's take the break now. And before we do, I'd like to leave you with this question for the break. And that is, and you have introduced the issue by referring to the available discretion to decide how much of the augmentation or the annuity goes to the individuals. I am not sure I fully understand, I'm saying this publicly, the minority decision of the Court of Appeal. But if you or the Crowns understand it to say there is only an individual distribution, do you say all of your arguments with respect, for instance, to the bring forward rate still apply? And I'll leave you with that for the break. You might get
That's some pretty heavy homework.
well. You can.
Yeah,
One
I'm gonna
second. If you
think
haven't-
about that and see if I can give you a good answer.
All right. So let's take the break. If you need an extra 5 minutes, you can.
Okay.
Thank you.
Court is stood down for 15 minutes. This court is resumed. Please be seated.
Well, that was a quick 20 minutes. There's a couple questions you left me with. The first one had to do with who is Carney. And I said he was the Commissioner of Crown Lands. In the database, in phase 1, the letters that he authored identify him as the Commissioner of Crown Lands. And in the stage 1, exhibit 10.1, Gwyneth Jones report, page 129, she identifies him as the Crown Lands agent at Sault Ste. Marie.
Thank you.
So he's described in the documents as the Commissioner of Crown Lands, but Gwyn Jones describes him by reference to those very documents as the Crown Lands agent.
Your Honor, if I may, on this point alone, Your Honor mentioned a cast of characters. I believe you were referencing what Dr. Alex Von Gernert provided at the end of his demonstratives. That's exhibit 52, and he describes who Mr. Carney was in his report there at page 171 of that exhibit.
Thank you.
The question you left me with was, well, what about the minority decision? Paragraph 4, I think you were referring to 415 of the minority decision, where the court says there was only one annuity. Well, I thought this court decided, and the majority decided there was only one annuity, but the minority seemed to think there were two annuities that, or that the
Like I
majority.
said, I don't propose to explain what the minorities.
Right. But the question is that under the minorities characterization, the entire amount is to be distributed to the members of the First Nation, and the graciousness discretion would apply to a determination of whether or not there should be an increase and the form of the increase. So under that scenario, the short answer is yes, the equitable principles will still apply, because let's just sort of think this through for a moment. If that were the case, the amount of resource rents from which to fund an increase would still be 126.3 billion.
Would still be the same.
It would still be the same. And the Crown, we would think, would still have a duty to consult and accommodate where appropriate. And one can imagine that the Anishinaabe would say, well, you've made a decision to keep it at $4. We don't think that that's appropriate. We don't think that that's in keeping with a diligent and purposeful fulfillment that seeks to fulfill the purpose behind the promise. And if the purpose behind the promise is to provide for both communities, and if the purpose behind the promise is to share in the wealth of the treaty territory, then the Anishinaabe would say, you have not complied with your obligation in accordance with the honor of the Crown. And we would be back into the exact same situation as took place in the Chippewas of Nawash case, where you have a breach of a duty of diligent and purposeful fulfillment, or a duty of a failure to comply with the honor of the crown, which would give rise possibly in an appropriate circumstance to equitable compensation. And in that instance, the argument that the individuals would make would be functionally equivalent to what we're making in respect of the collective. The difference, I think, is that the discretion, the difference in the two approaches are in one, in the real world, based on the existing judgment, the existing Court of Appeal decision, it is the court who is the final arbiter of what happens if no agreement can be reached. In the minority's view, there doesn't have to be an agreement sought. There can be consultation, but that doesn't have to be an agreement sought. And the court's role in the minority's view is more subdued. But ultimately, when I say more subdued, because you're not making the correct decision, the court would be reviewing the decision that the Crown makes to see if it's in accordance with the honor of the Crown. But in either instance, both the individuals or a group of them complaining about the smallness of their annuity, or the collective complaining about the breach in this case, they'd be pointing to the failure to honor the treaty commitment in an honorable way and failing in diligent fulfillment. And they would both be saying, what we lost is the opportunity to use our funds going back to when they should have been paid. And then they would be arguing, we would have used that money and this is how we would have used it, and you would have had the same evidence or
Would
difficulty.
there have been the same evidence if the money were all in individual hands?
If the money were in individual hands, you mean if the money, well, it depends. Okay, if you want to go down that thinking path.
Well, I'm
Yeah,
wondering if that's where the court must go, or that's the alternative, if the minority, in the minority view, is that
Yes.
where the court would be left?
I think the court would be left with a situation where one would then ask, would have to ask, what are the realistic contingencies of what the individuals would have done,
Right.
right? And there you get into, I think, an analysis on an individual basis. It makes it, I'm not sure whether it would be a class action would be an appropriate, I'd have to think about that, whether a class action would be an appropriate way to proceed if it's not a collective entitlement. If it's only an individual entitlement, not a collective entitlement, we run into some problems. But each individual, would each individual then have to come to court and prove, if I would have had that money in 1973, I would have invested in Apple, or I wouldn't.
I'm not so much asking what the proof would have been,
Yes.
but whether the arguments that have been brought, that have been made, apply. It's a tougher question for you, and maybe you don't have it, but
No,
arguments that have been made about what communities would have done.
Yes,
That's an argument based on what communities would have done.
that's correct. And that's fair. So the question would be, what would the individuals have done? But those individuals would be saying, they would be making similar arguments about, well, maybe I wouldn't have had as much money as the collective, but darn it, I would have used that money to feed my family, and I would have used it. I mean, the rates of return on individuals would probably be higher, but on an individual level. Yeah, yeah. Ms. Lewis is reminding me that Chief Machado did give evidence that what individuals would do if they got the money is invest in businesses and the like, which give a rate of returns higher than 7.2%. And Professor Stiglitz gave evidence about how if individuals have, a poor individual having funds, it gives a rate of return investment on human capital, right? So they would be, I guess, if you aggregated the individual claims, they would probably far exceed the 7.2%.
Right.
But again, that's not the case we brought. I hope that answers the question, but if you have more questions about that, I thought it was intellectually stimulating, but
Sorry to do that.
no, that was interesting. Next, I was going to turn to justification. We say the justificatory standards inform the remedy, even absent a defense to justification. Now, Canada admitted to breaching the treaty obligation to engage in a process. Ms. Evans for Canada admitted this in her oral submissions, and my notes say she pointed to Canada's argument at paragraphs 29, 430, and 432. Both crowns admit in this case that there were positive amounts payable in the past that have not been paid. While both calculate very small amounts are due when compared to Stiglitz and Hutchings calculations, the fact remains that the Crown has admitted that there has been a breach of the treaty obligation to make payment when due. We say the law is clear. Where there has been a treaty breach, the Sparrow justificatory analysis follows. Neither Crown, in their evidence, written submissions, or an oral argument, addressed justification. Now, yesterday, Ontario argued that the plaintiffs are alleging that the treaty breach is an obligation to maximize the revenue from resource rents. That is not what we say the treaty obligation is. There's no obligation to maximize it. There's an obligation to engage in a process by which they could be maximized, but not an obligation to maximize them. There is a treaty breach by failing to make payment of the annuity in the past for the amounts properly due. And there is a breach of the duty of diligent and purposeful fulfillment. After 173 years of inattention, there is no room for doubt that the treaty obligations of engagement and payment have not been fulfilled in a diligent and purposeful manner. The court will recall that in MMF, there was a 10-year delay, and that was sufficient for the Supreme Court of Canada to characterize the Crown's conduct in that case as being inconsistent with the duty of diligent fulfillment of the promise. The delay in this case is all the more egregious. I remind the court that what Rio Tinto said, that's a Rio Tinto Supreme Court of Canada, 2010 SCC 43 at paragraph 49, the court says that past proven breaches of the duty to consult can attract damages, and so they should in this case, for the failure to diligently and purposely fulfill the treaty. But getting back to Ontario's complaint about maximizing the revenues, we say that there's the breach of engaging in the process. And we say that it then behooved the Crown to bring forth evidence of justification. And when you look at the kinds of things that justification requires, that's at paragraph 191 of our reply document. And I'm just going to read the 5 criteria that were identified in an article by the late Peter Hogg. Has there been consultation and accommodation? Is there a compelling and substantial governmental objective? Is there a rational connection to the governmental objective? Did the Crown seek to minimally impair the Aboriginal interest at stake? And 5, has the Crown demonstrated that there is proportionality of impact on the Aboriginal interests? These guideposts, if you will, for the justificatory standard help inform the remedy that this court should bring. Now, Ontario and Canada sought not to bring evidence touching upon those very important matters that might help guide you. So when you think about the failure of the Crowns to bring evidence on justification, it is akin to the evidence that they should have marshaled in defense of the plaintiff's claim to a money judgment. And the court will recall that at common law, there's an obligation on each litigant to bring forth evidence in support of their case and in defense of their case that is within their power and control to bring. It's not a legal burden, it's an evidentiary matter. And if they don't bring that evidence, they do so at their peril. And so in this case, we are not saying that there's a treaty right to the maximum revenues. We're saying there's a treaty right to a share of what the Crown got, and there's a treaty right to an engagement process. And it behooved the Crown to bring evidence as to why the decisions they made were reasonable, appropriate, commensurate, proportional, in pursuant of government objectives. But we had none of that. We just had data from the public accounts as to what happened, not why it happened.
You say there was an obligation, an evidentiary onus to prove reasonableness of decision.
Yes, I do. If they want to defend the decisions they made and say, we could only properly get, let's use Stiglitz and Hutchings direct NCRRs of 56 billion or so. If their position is, your suggestion, Mr. Schachter, and your evidence about how we could have gotten more or that the engagement process would have led to something, well, they had an obligation to say, here's why we couldn't do it. Here's the policy principles in place. And here's why it would have been wrong for us to employ the I'm going to call it the Carney principle, to, not allocate or treat assets given away as though it had some value. I say that that was an evidentiary burden that they did not meet. And so it factors into not the treaty right, but into the quantification of the loss for the breach, which is a different situation.
Thank you.
I was going to turn to a new topic there, new topic now. And I've touched on it already, but I see in my notes there are a couple of other points I need to make, and it has to do with, I believe the Crowns have confused the elements of our losses So, and the first 2 points I think I've already made. It is, you've got the treaty right to be paid a share of the net Crown resource-based revenues that ought to have been paid in the year that they were payable. So thus, in this case, we're saying we had a treaty right to share in the direct and indirect net Crown resource revenues. That portion of our claim is a share of, again, using Stiglitz and Hutchins, 77 billion. But our loss is not confined to the Crown's failure to pay the amount owing by virtue of those treaty terms. There is a second treaty right that the Crowns must answer for, the treaty right to an engagement process. And I've already talked about the genesis of that treaty right.
And just as an opening to that,
Yeah.
I take it that we don't have any jurisprudence on failure of duty to engage. We have failure of duty to consult. Do I have that right? And do you say that we look to analogy at failures of duty to consult similarly to failure of duty to engage?
No, because the fundamental difference between an engagement and a consultation process. Remember, the engagement process is to seek agreement among treaty partners, failing which the court will decide. A consultation process is to consult and the Crown to exercise its decision making power to be reviewed I take it on probably on judicial review for failing to come up with a decision that's reasonable and in accordance with the honor of the Crown. So in that sense, they're different. Can you get any guidance at all from where some of the courts have looked at whether the Crown has acted honorably? Yes, I think you can. I think I'd be pushing it too far to say you can't get some guidance from it, but the two are fundamentally different.
Yes, I wasn't looking for the nature of the duty,
Yeah.
rather the nature of the remedy.
Well, no, yes, I think you could look to that for the nature of the remedy, yes.
Thank you.
Because I think there are some similarities there in terms of the two. Now, it is in respect of the lost opportunity, I want to make sure the court understands is where we get into resource rents becoming relevant. And remember, the 126.3 billion in resource rents available to be captured, we say, is a good proxy for the value of the treaty territory on a wait and see approach. It's a good proxy for what the Anishinaabe brought to the table. We also concede that it's an upper bound onto what the engagement process could have resulted in the Crown capturing, and that's an important consideration for the court. And it's also important to know what that figure is, because we also know that it's less than the relative wealth deprivations that were suffered. So the resource rents calculations provides some boundaries and some guidance, not exact amounts. We don't pretend that it does.
We have 1 minute, please.
Yeah.
Go ahead. Thank you.
Turning to a new small section on res judicata, issue estoppel, and abusive process. Very briefly, neither Crown alleges res judicata, issue estoppel, or abusive process nor the principles of stare decisis apply as against the plaintiffs. Ontario and Canada both made this clear before you. I just make a note that Ontario, in its oral presentation on September 21, made reference to paragraph 49 of its pleadings. That was a pleading in the statement of defense to us that invoked res judicata and guardian ad litem on the part of the Crown, federal Crown. That has been abandoned. So please keep that in mind. They are not, Ontario is not pursuing and did not pursue and does not pursue res judicata, issue estoppel, abusive process, or claiming that Canada was the guardian ad litem for the plaintiffs, and that we are bound, we, the plaintiffs, by any release that might be effective as against Canada.
And you say that was abandoned by virtue of the arguments made in this?
No,
that
it was abandoned, I think, either in phase 1 or phase 2. I can't remember exactly where, but it was confirmed before you. And I think it was perhaps just a slip as council was going through all the various places where they've pled it. They just included paragraph 49 of the defense to the plaintiffs. And I thought that was just a slip.
Thank you.
Just a slip.
Oh, when you said justice, it was just as counsel.
Next topic. Is value still relevant, and what to make of it? Canada's made an argument that value was removed from the judgment and that value has many meanings. We say that this argument is unfair and really does not tell the full story of what happened to value. We remind the court that the Court of Appeal at paragraph 301 says this about value. It is clear that a monetary conception of value was being employed and that the value in question related to revenues produced from the activities in the territory. So there's no doubt that the conception of value that everyone was talking about was economic value. So the complaint about value having many meanings falls away. But secondly, while the word value fell to the cutting room floor from inside the judgment, it fell as being part of the phrase fair share. The importance of value, however, was not at all lost sight of by the Court of Appeal. This court should remember what the Court of Appeal said at paragraph 289 about value. I'll start at 288. The judgments provide that the treaties require the payment of annuities corresponding to a fair share of the value of the resources, including the lands and waters in the territory. We would deconstruct the judgments into two possible promises for analytical purposes. The first is that the augmentation clause was a promise to share in the value of the land. The second is that a fair share was promised. The first form of promise to share in the value of the land is supported on the evidence and was woven throughout the trial judge's interpretation of the augmentation clause. The same cannot be said for the second form of the promise, the elusive promise of fair share. We address each in turn. So far being irrelevant to your consideration, value remains quite relevant. Next topic I wanted to turn to was some argument put to you by Ontario Council to the effect that rents are not relevant because the Anishinaabe brought to the table only unprocessed, unexploited natural resources. And you might recall that my friends from Ontario put to you paragraphs pages 7619 and 7621 of the transcripts when Professor Bodway was testifying, but they neglected to put in pages 7620 and 7622. And I think it's important to maybe look at them in their context. So a more fulsome context than just 2 pages in and 2 pages out. And so I've collected those pages at tab 8 of our reply compendium exhibit QQ, page 37 of the compendium, tab 37, starting at page 7619. My friend in Ontario, if you look at towards the bottom of the page, I guess lines 15 through 18 said, I find that an ambiguous description because the Anishinaabe brought to the table was not anything produced. It was unprocessed, unexploited natural resources. Now, that is the quote Ontario took you to, but let's go over to the very next page, page 7620, that Ontario omitted. The exchange continues. Question. Okay, so you don't conceptualize it, but you're aware that Stiglitz and Hutchins have this idea of what they brought to the table as important. Answer, yes. Question. And would you at least agree with me that while you don't agree with their opinion, it's a reasonable opinion for an economist to have? Answer. Depends what purpose you're using it for. Question. Well, for the purpose of trying to help the court understand what the Anishinaabe brought to the table. Answer. In the context of the way in which Mr. Hutchins and Professor Stiglitz used what they call what the Anishinaabe brought to the table, it's perfectly reasonable. And as an input into their approach to sharing, which is the joint venture risk sharing approach, I don't have any objections to that language. The very next page, 7621, Ontario brought your attention to the witness saying at the bottom of the page about what they brought to the table being problematic because they didn't bring rents to the table. They brought lands and resource unprocessed, unexploited. I'm going to come back to that in a moment. But if you look over on page 7622, just before the first paragraph before the court asks if they understand, the witness says, and I don't find bringing to the table to be of any help to me in understanding the bargaining procedure, but I'm happy to accept it as a useful way of conceptualizing it for the purpose of the joint venture. The court, let me see if I understand, the witness chimes in. My objection is not essentially to what they did or did not bring to the table. It's more with the sharing mechanism itself. So far being unimportant about what Professor Bodway said, a more balanced approach to what he said is he is agreeing that for the joint venture approach, and the approach Stiglitz and Hutchins took, it was not an unreasonable approach. I want to tell you one further thing about this that kind of makes that gives us a sense of the difference between the ivory tower and the real world, between a technicality and a reality. I think, if you think about it, Professor Bodway saying, well, they're unprocessed. They don't have value yet because the nickel is just sitting in the ground unprocessed. It doesn't have, those aren't the economic rents. The economic rents are the excess profits. Well, the excess profits haven't happened yet. But if you're looking at it in terms of what's the value of what's there, let's use common sense. If I'm a buyer of a land with a gold mine on it, and I know there's a gold mine on it, I'm going to pay the price of the land not as though the gold wasn't there. I'm going to factor in my purchase price that I'm going to offer the potential of the resource rents. And
Say, with a gold mine on it or with known gold reserves? You already seeing a mine built on it?
oh, it doesn't matter. The purchaser knows that there's 1,000 ounces of gold.
Okay.
They're going to, when they decide on the purchase price, they're going to say, well, okay, there's 1,000 ounces of gold there. In addition to, I could use it for hay, or I could use it to build a nice little house beside my 1,000 ounces of gold. But the purchaser is going to look at the potential of the resource rents. They're going to look at it. So it's really quite a technicality to say, aha, those aren't the resource rents because they haven't been extracted yet. But in terms of the value, well, the value is there. It just hasn't been realized yet. And in the common sense real world, people recognize that value.
When they are, let's say, known gold reserves.
Yes, when they're known gold reserves. And I want to then continue at page 40. Of the compendium. We get to, 41 of the compendium, excuse me, which is actually a different series of questions in respect of Mr. Bodway's testimony at pages 7734 and 7735. And I just want to read and remind the court what Professor Bodway's ultimate conclusion was. Question, and this is at line 14 of 7734, but you appreciate that Stiglitz and
You say, page 41.
page 41 of the compendium,
Thank you.
question, page 7734, and we're looking at line 14. Question, but you appreciate that Stiglitz and Hutchins did try and value rents. Answer, I agree with you. I mean, we did the same thing. We said, let's just treat stumpage fees as NCRRs. And our version of NCRRs is NCRRs should be taxes that the Crown gets from rents. So we use stumpage fees as if they were rents. But the point I'm trying to understand, question. But the point I'm trying to understand is Professor Stiglitz and Mr. Hutchins, they actually had two sets of numbers. They had one set of numbers for NCRRs, and they had a higher number for rents. Answer, oh, I get your point. Yes. Question. And I was concerned, says the questioner, and I'm glad that you're correcting me for this. You're not suggesting that what Stiglitz and Hutchins did in determining rents was somehow improper the way they calculated the amount of rents? Answer, no. Question, thank you. Answer, sorry if I left that impression. So although Bodway and Smart did not calculate rents, Professor Bodway, who I described as a fair-minded witness. And I think all the parties would agree with that. Didn't think that Stiglitz and Hutchings' calculation was wrong. It's an important fact for you to keep in mind.
Well, as I understood that evidence, there was a debate over approach, but not over how the approach was explained or put before the court in terms of with the use of data.
Well, yes, but when it came to the calculation done on smart Stiglitz and Hutchings' approach, Bodway is saying he doesn't have any concerns about the calculations, but he says there were limits to it and problems, with it. Stiglitz and Hutchings, we're going to get into this in a moment. They weren't really cross-examined on that, but to say that there were concerns and that you can only estimate them, and okay, fair. Stiglitz and Hutchings didn't say they were doing anything but estimating it. So that actually brings us right to the Crown's attack on the methodology and calculations of Stiglitz and Hutchings' resource rents. I find it interesting that Ms. Crew for Canada spent some time explaining how the lack of data in this case requires the court to do its best that it can. And I think that that is an invocation that is fair. What I didn't think was fair was when Ms. Evans took the podium to ask you to reject Stiglitz and Hutchings' rent analysis because it lacked precise data with which to measure resource rents. And the point is that Stiglitz and Hutchings explained that their calculations were but an approximation. Moreover, recall that Stiglitz and Hutchings explained that, in their opinion, it was only where there was a lack of reliable data that they went about and used NCRR figures, the actual NCRR directly captured amounts. So the case about using unreliable data is not, in my respectful view, a fair one. So where they had reliable data, their evidence was we used it. We recognized where we didn't have reliable data. So Stiglitz and Hutchings, we just fell back on NCRR figures. In my earlier submissions, I've discussed that all experts agreed that resource rents was a term all experts shared and an appropriate place to start, and that the Crown, as the owner of the resource, has an interest in trying to collect 100% of the resource rents, and that the experts all agree, save for Mr. Smart, that it might be, who said it might be possible that the Crown captures rents indirectly. So I'm not going to go into that, but I'm going to go on to the next point, which is the Crown experts, Bodway and Smart, refused to engage in a consideration of net resource rents themselves as being a relevant consideration. They opined that the only consideration that mattered was direct resource rents. Now, we say that this was a mistake and that resource rents do matter when this court considers the issue of the lost opportunity and the past compensation due for that last opportunity to engage in a process. What has happened is that the Crowns have simply ignored the plaintiff's case. Even in the most basic of cases, it is a perilous strategy indeed to ignore the plaintiff's case on the hope that your one defense position will be successful. Court might not accept your position. And in fact, this is what the Crowns have done. They have had ample opportunity, ample notice, and ample time from the time that Stiglitz and Hutchins provided their reports to do their own calculations of resource rents. But the Crowns and their experts chose not to do so. On September 19, 2023, at page 109 of the day's transcripts, I've got a note here that Your Honor asked Canada's counsel, where in the record is there evidence that Stiglitz and Hutchins' work was unreliable? And my recollection was that Canada pointed to the reports of Mintz and O'Riordan and Bodway and Smart. But this court should remember that Stiglitz and Hutchins replied to all of those concerns in their reply reports. And you might recall that they were on the stand and waited for any substantive cross-examination which never came. Respectfully, the time and place to test the opinions and conclusions of Stiglitz and Hutchins was in cross-examination. Respectfully, it is a time that went by without meaningful cross-examination on both the methodology and their calculations. I want to turn to Canada's assertion that excess profits cease to be excess profits if industry takes them. That was an argument put forward by Canada on September 19, 2023. Now, Professor Mintz aptly described resource rents as excess profits, either collected by the Crown or industry over and above reasonable rates of return to capital, labor, and supplies. And you can find that if you want in Mintz direct examination transcript, page 2665. Canada argued on September 19th that if industry takes profit greater than a reasonable rate of return, then what they take ceases to be resource rents. Respectfully, this argument is inconsistent with their own experts' definition of resource rents. Recall that in calculating resource revenues and the excess profits that make their way into the hands of people other than the Crown, Stiglitz and Hutchins used the actual real-world data of competitive returns actually taken by industry in the past. It was not by them any hypothetical world. And it was not based on whimsy. It was based on a methodology that looked to actual reasonable rates of return to capital, labor, and suppliers. And it was a methodology that was not challenged in court. My next topic is reminding the court what Bodway and Smart's expenses are. We have already explained that Bodway and Smart do not attempt any matching exercise. They do not attempt to match the expenses that support relevant resource revenues. We say that's a fundamental error. The Crowns say that Smart and Bodway's approach was practical, logical, and reasonable. We invite the court to conclude that their approach has none of these attributes. Their approach is inconsistent with the principles of treaty interpretation and the animating principles of respect, responsibility, renewal, and reciprocity. Recall that they identify expenses of 2.897 billion nominally. We've got that figure in our initial compendium exhibit II at tab 4. But they call those expenses that support resource rents. But they are not simply expenses that support resource rents. They are in fact expenses that support all Crown policy choices and all revenue streams, even those that are unrelated to NCRRs and unrelated to the resource rents captured by the Crown and captured by others. We know this must be true because they never calculated what the resource rents were. The first step in asking, well, what expenses support resource rents is to ask, what are the resource rents? Without answering that question, the data in the public accounts cannot be about the expenses that support resource rents alone. It's about expenses incurred by the Crown for any purpose that incidentally affect resource rents generally. That's a different question. And that's why when you look at tab 4 of exhibit II, you will see that while Stiglitz and Hutchings Crown expenditures for resource rents is more than the Crown expenditures for NCRRs, it's nowhere near 2.897 billion.
Was that, oh, that was expenses, right?
Right. So, you know, Hutchings and Stiglitz's expenses for rents are more than, as you would expect, right? The amount of expenditure that is reasonable to support, collect, regulate resource rents would be higher than direct resource revenues, but not to the kind of extent that Bodway and Smart identify them as 2.897 billion. So you couldn't just match rents to rents, is the point I'm trying to make.
You couldn't just match
Stiglitz and Hutchings rent calculation.
expenses.
No, rent revenues of 3.586 and then deduct off Martin Bodway's
2.897.
2.897, because the 2.897 doesn't mean anything. It doesn't, it looks like it's expenses that support resource rents, but it's actually expenses that support everything. We have no way of knowing what portion of that 2.897 is used to support rents because we don't have a figure from them as to what the rents are. Because maybe in their exercise, using their theory, perhaps the rents would have been 7.5 billion, not 3.5 billion. We don't know what their answer is. We just know that the 2.897 is not a reliable number for the court. So I don't want, my point of raising this is I don't want the court to think that, you know, one way of dealing with this is to go to Stiglitz and Hutchings rents and then take off Bodway and Smart's expenses. That would be wrong, in my view. I see it's 12:30 and I was about to start a new topic. And judging from where I'm at, I've probably got about an hour and a half to go.
Very good. Okay, let's break now till 2.
Yep.
Court is stood down until 2 p.m.